My name is Tony Kuhn. I am the managing partner of the Buffalo, New York office, and I am the chair of our firm's military and the chair of our firm's national security practice groups. I am an Army veteran of 26 years in the Army and Army Reserve, and this is why I practice in this practice area. Eric Duncan, my colleague here, we work together in the Buffalo office. Eric is also a military law attorney, and Eric is a Marine Corps veteran. So again, this is why Eric chose to practice in this practice area. So we do have a big team of military law attorneys. Actually, Eric and I were just talking about some statistics before we kicked this off. We looked at the numbers today. We're up to 20 veterans at our firm. So it gives you an idea of how we feel about the veteran population. We like to be involved in the veteran community, and we appreciate that you all are able to jump on and participate in this webinar with us. Eric, our contact information is on this slide here. If you want to shoot me an email or Eric an email, and you can also find it on our website at tullylegal.com, or if you look up Tully Rinckey, it'd be pretty easy to find the website. Just a quick disclaimer, some of the things we're going to talk about today, we can't teach everybody how to draft their own legal brief in an hour. We don't have enough time for that. It took us 7 years of school, so you're not going to learn how to draft a legal brief today, but we're going to kind of do a high-level review of discharge upgrades, and based on a lot of the questions that we got in the pre-screening for the registration, we're going to talk a bit about medical disability retirements as well. So this isn't legal advice. If you have an ongoing case, we're not going to tell you if they're doing it right or doing it wrong or anything like that. We're going to talk in general terms today. So if you have any questions and you want to follow up, feel free to follow up with us and we will go into more detail and talk about your case. I saw the names on the registration, and I do recognize that a handful of you are current clients of the firm. So thank you for jumping on, and we hope that you learned something today as well. But if you have any questions about your case, feel free to jump in and give us a call after, shoot us an email or something like that. We'd be happy to answer the questions. So just the first thing, not everybody, we're not going to be, we hope we don't sound patronizing at all throughout this presentation today, but we don't know what you all know and what you all don't know. So we're going to start at the floor with some of the information that we provide. So first thing just to consider as we get into this is the types of discharges. So or classifications of service, sometimes they're referred to as. Obviously the best one is an honorable discharge. That's what you all want, right? That's what gets you all the benefits, education benefits, service-connected compensation, burial benefits, things of that nature. As you go down the scale there to the lower classifications of service, you start to lose some of those benefits. For example, the one below honorable is under honorable conditions. Many of you hear this referred to as a general discharge. A general discharge means that you don't get the education benefits that you would have gotten with an honorable discharge, but you will get some benefits. You will get service-connected compensation and things of that nature. Now, if your general discharge follows a period of honorable service, in other words, you've got a DD-214 that is an honorable discharge, you're probably entitled to all of the benefits of an honorable discharge. So don't think that just getting a general discharge later in your career is going to bar you from benefits that you're already entitled to. If you have that earlier honorable discharge, a lot of times you can establish eligibility for those benefits. A lot of people don't understand that, and that's something that's very important. The VA, sometimes their employees don't understand that. And sometimes we'll win an appeal just based off of showing them that this individual has an honorable period of service, and then they reverse course and they award the benefits. So keep that in mind. There's a bunch of dishonorable discharges. I don't have them all listed here. I have the ones that we use now listed here. We don't use undesirables and things of that nature. There's some discharges from years ago that the military has basically stopped using. What you see now mostly is other than honorable discharges, and that's for an individual who is discharged administratively. So maybe there was a pattern of misconduct, or they failed a drug test, which requires mandatory processing for separation in most cases. Something like that will generally lead to an other than honorable discharge. With an other than honorable discharge, you get very few benefits. One of the benefits you'll still be able to get is medical treatment for a service-connected condition, things like that. And then, you have to show that the condition is aggravated or incurred while on active duty. You have to be able to draw a nexus between the current condition and that injury, and you have to prove that it's service-connected, which can be tough because the VA is going to want to turn you away and tell you that they don't even want to hear your case, but because you've got an other than honorable discharge. If you can get the condition service-connected, you can at least get medical treatment for the condition with an other than honorable discharge, which is another thing that a lot of veterans don't understand. Something to consider if you have an OTH and you have medical conditions that you think were caused by your military service. And then lastly, we'll talk about the bad conduct discharges briefly. That's for individuals who were court-martialed. You got kicked out of the military, you got court-martialed and convicted of something that resulted in what we call a kick or a bad conduct discharge. You get very few, if any, benefits if you have a bad conduct discharge. All right. Just know going into this that each branch has a specific regulation that deals with upgrades and boards for correction of military records. So if you're going to try to go about this on your own, make sure that you've read and understand those regulations. There's rules that you have to comply with. For example, the Air Force puts a page limit on their applications, and they want to see that the application is double spaced. Will they kick it back if it's single spaced? Maybe, maybe not. But why take the chance? If you understand the rules and you don't violate the rules, then there's a better chance that they're going to review your application and then, potentially provide some form of relief. Not a great chance with the Air Force, but they're a very difficult board to work with, but they're also the one that has the most rules. So make sure that you review the rules and the regulation for that board before you apply to it. And then also know that there's a website down here at the bottom. We have the link in the slideshow here. There's a website. If you Google reading room, you'll be able to easily find that website. We call it the reading room. And it is a website that has an Air Force address, but it contains decisions from all of the military branches. It contains some of the forms that you'll need to apply to the boards. It contains decisions that you can use to be persuasive. They're not controlling. They're not going to control whether the board sides with you or not. But what you want to do is you want to show the board that you're not the first person asking for this form of relief and that they have granted this form of relief before. See this case. And if you can show them that case, then it increases your chances of success because the board members don't feel like they're being asked to do something that the board hasn't done before. So that's something that's valuable in a case, and you can find those cases in the reading room at this website link that I have in the slideshow here. Want to add anything to that? We good?
No, I think we're good.
Okay. I'll talk about the different boards that we go to.
Yeah. Okay. So there's two main boards that you'll often apply to when you're trying to get a discharge upgraded. The first one is the Discharge Review Board. It is really the first stage of review. The DD Form 293 is the application for a discharge upgrade. That form needs to be submitted or the board will not consider your application. There is a 15-year statute of limitations, which is strictly enforced. So if you're 16 years out or 15 years in one day, the board's going to deny your application. They only have the ability to upgrade your discharge characterization. A lot of times you will see veterans or you'll get people that want administrative data corrected. And by that, I mean narrative for separation, your re-enlistment code, medical retirement, things like that. Board doesn't have the cognizance to issue any of that type of relief. Anything or any relief you're seeking in that regard needs to go to the Board for Correction of Military Records or Board for Correction of Naval Records. The BCNR is going to handle your Navy and Marine Corps cases. There are two standards that the boards are looking for the Discharge Review Board. It's impropriety or inequity. For the Board for Correction of Military/Naval Records, you're dealing with error and justice. Phrased differently, but essentially it is the exact same standard or the exact same standard of relief. You do have the right to a personal appearance before the Discharge Review Board. Compared to the Board for Correction of Military/Naval Records, there really is no right. You can check the box that you want a personal appearance, but typically they won't grant it unless it piques their interest. For the BCMRs/NRs, the form you're going to need is the DD Form 149. there is a 3-year statute of limitations from the date of discovery of the alleged error or injustice. Now, a lot of times, it may be 20 years, 15 years before you realize there's even been an error or injustice. The board will routinely waive the statute of limitations. The BCMR/NR can grant a wide range of relief. And this goes back to what I was just talking about previously with correction of administrative data. They can change your regular separation to medical retirement. They can remove bad paperwork from your file, like a GOMAR, bad OPR, things like that. Again, there's no right to appear there. You can request it. They're probably not going to grant it, though. And the standard that they're looking at is an error or injustice. Anything else you want to add?
Just that there is a duty at these boards to exhaust administrative remedies. So if you jump straight to the Board for Correction of Military Records and you're within the 15 years of discharge and you're requesting a discharge upgrade, they're going to sit on it for 2 years, and then they're going to tell you that you applied at the wrong board and you failed to exhaust administrative remedies. What they mean by that is you need to start at the appropriate board, and in this case it would have been the Discharge Review Board, and if they shut you down, then you can appeal and you can move on to the Board for Correction of Military Records. Or as Eric was saying, they'll waive the statute of limitations, so sometimes we get 30 or 40 years from the discharge. We still can go to the Board for Correction of Military Records or Naval Records and just argue that they hear the application in the interest of justice, and they usually grant our request. So you have that requirement to exhaust administrative remedies. If you are National Guard, and this only applies to National Guard, then you have to start at National Guard because it is a state entity. So you have to just send a letter or request some type of relief from the National Guard. Send it right to the TAG, the Adjutant General, somebody who's going to ignore you anyway, but you have to request it so that you can then show that letter, show proof that you mailed that letter, and show proof that you've exhausted your administrative remedy before moving on to the boards. And also keep in mind that these multiple steps in the process give you more bites at the apple. So it's more chances to win your case. If the TAG is responsive, and they almost never are, but if they are, then maybe you can get relief at the state level. Maybe then you move on, if not to the Discharge Review Board, you can do a paper review at the Discharge Review Board. Then you have the right to a hearing at the Discharge Review Board. Then you can move on to the Board for Correction of Military Records. Now you're looking at 4 bites at the apple, 4 chances to win your case. So if you're strategic about it, there's a good chance or a better chance that you'll win at one of those stages than if you were to just file at one board and hope that that board grants relief. Keep going. You're killing it.
Yeah, I can go. All right. So DASEB, Department of Army Suitability Evaluation Board. That is going back to the exhaustion of administrative remedies. That's going to be your first bite at the apple for removing that bad paperwork, your GOMARs, your OERs, and NJP. There are limits on who can actually apply to DASEB. Any officer, warrant officer can apply. For enlisted, you got to be E6 or above. They're typically looking to see whether or not the bad paperwork, meaning the OER or the GOMAR, is either untrue or unjust in whole or in part. There's specific regulations, obviously, that deal with removing this. I don't recall the regulation off the top of my head. But your standard there, or really what you're looking to show, is that some language inside that GOMAR or inside that OER is incorrect. In order to exhaust your remedies, you're going to DASEB. If for some reason they deny relief, then you're moving on to the BCMR. The other board you have is the Physical Disability Board of Review. That is to challenge PEP findings, which is the Physical Evaluation Board. That goes to your IDES, LDES processing when you're getting separated or being proposed to be separated based on some type of medical disability. If for some reason you were to get denied at the PDBR, you can then go ahead and move back on to the BCMR or the BCNR. The DAR, which is the Discharge Appeal Review Board, was just recently created, I believe, about 1.5 years, 2 years ago. Unlike the other boards where you're really not, you can't file an application, meaning you can't put together a petition, you can't give them new evidence, you are stuck with whatever records you created moving up through that chain. You do have a strict 1-year time period to submit or appeal a BCMR decision to the DAR. Again, you got to make sure you're exhausted all these remedies when you're moving through this process. Anything anything else you want to add?
Nope, just Eric talked earlier about making sure that you include the proper form. It's happened to us before where the everything was right. The packet was very thorough. It was a very good packet. It was a request for reconsideration. The individual had applied, I think, 3 times and lost all 3 times. We drafted a very thorough application to the Navy board and we submitted it, but we had the 293 instead of the 149, and the board just threw it in the garbage and didn't even tell us. So it took us a year to get an update on that. We found out, and then obviously the individual was upset about it. It's all the same information. It just had a different nomenclature down at the bottom of the form. So we initiated requested a congressional, and refiled immediately with the board. It probably took them a week or 2 to adjudicate the new application and grant relief. So they granted the upgrade, but it was just frustrating that we had to go through all of that. So make sure that if you apply, that you're using the appropriate form and don't forget to include it.
And not only the appropriate form, they actually put expiration dates on those forms. And I believe both the DD-293 and the 149 are expiring at the end of October, actually, and then January. So make sure you're paying attention to that as well.
Yeah, use the appropriate form. You should be able to find that information in the reading room or online. The current form we're using is only, I think, less than 2 years old. It's not a very old form. All right, so some common filings or strategies. This is where we'll get into some of the different types of relief that we request. I'll talk about a couple, and then Eric will talk about a couple, but the first 2 we'll talk about are discharge upgrades based on mental health and upgrades to a medical disability retirement. So for mental health, this is the one that generally has the best chance of success. Discharge upgrades based on military sexual trauma, don't ask, don't tell, things like that have a similar success rate, but just know when you can look at the statistics in that reading room that we talked about earlier, and the statistics appear as though they don't like to grant relief. They grant a very low number of relief in these applications.
17 to maybe 30%.
Yeah, depending on the branch. Air Force is even below that. Air Force is single digits. But here's what you need to know. That is the statistics for the entire number of people who apply. And the majority of people apply. Some of you might have tried this. Just fill out the form and submit the form. You're not going to win your case that way. It's just not enough. You're not going to convince anybody that there was an error or injustice. You need a thorough brief. You need supporting documentation. You need to build out the record. You need to give them a reason to upgrade your discharge. And if you submit a very good packet, then your chances of success will skyrocket compared to the statistics that you see on that website. If we get for example, a PTSD application, an individual who you can see the order of events here. So good soldier, traumatic experience, misconduct follows the traumatic experience, and then we can show that that individual was suffering from PTSD, diagnosed, undiagnosed, doesn't really matter. We can get it diagnosed at the time that we apply if we need to, but you can show that there's mental health issues that were the underlying cause or contributing factor to the misconduct. Then if we get a case like that, we're almost guaranteed to win that case. It's a very high level of success on those cases. We can't guarantee anything, but I'm telling you that it's an extremely high level of success on those cases. If somebody else applies and does just the application and doesn't support the application well, you're probably not going to win that case, even though it's the same underlying fact pattern. It just depends on how the packet is compiled and submitted and what supporting documentation is included. So our statistics are extremely high compared to the board's statistics, published statistics. I have no problem saying that I win far more than I lose when I apply to the board, but obviously we don't win them all, unfortunately. So down to upgrades to medical disability retirement, I just want to really quickly explain the medical disability retirement process, and then we'll talk about how we can potentially, or how you can get those upgraded. So there were some questions about the process. So generally, all of the branches are the same. There are some minor differences between the branches, but they start with a medical evaluation. So some doctor or commander has identified an unfitting condition, meaning the service member is unable to perform the duties of their rank, grade, or rating because of some medical condition. They will identify that condition and they will refer you for a medical evaluation of that condition. The medical evaluation board generally determines what conditions will go forward to the physical evaluation board and if those conditions are fitting or unfitting. If they think that you have a condition but you're fit, they'll put you back to work. If they think that you have a condition that's unfitting, they'll move you on to the physical evaluation board, or the PEB. Now, again, I'm cutting some steps out here, but just explaining generally how it works. So MEB is the first stage. If they say fit, back to work. If they say unfit, over to the PEB. You can respond to and essentially appeal that decision and get some changes made to that decision before you go to the PEB. Don't think that you can't. You go to the PEB or the Physical Evaluation Board has multiple stages. The first stage is the informal Physical Evaluation Board. Just like the Medical Evaluation Board, the informal or IPEB is a paper review. They're just going to look at your records like they did at the MEB. If they, at that time, determine that you're unfit, they will assign a percentage. And if that percentage is 30% or higher, then you'll be entitled to a medical disability retirement. If it's 20% or lower, then you should appeal it no matter what. Don't ever, under any circumstances, accept severance pay. It's garbage. If you accept severance pay, which some of you probably have if you're on this webinar, and a JAG advised you to accept severance pay, in my opinion, he came very close to, if not committed, legal malpractice, because it's terrible advice. They did not have your best interest in mind. It's just terrible advice. If you tell somebody to accept severance pay, what happens is they take this lump sum payment, they get a check, they cash the check, they get $100 grand. It's a big number, it looks great, you take that money, and then your VA compensation that would have kicked in as soon as you get out of the military is cut off until you pay back all of that money. So you essentially got nothing. You get no retirement benefits, you get no service-connected compensation until you pay back that $100 grand or whatever that number is. So they called it a severance payment, they paid you to go away, and then they take all that money back away from you because you're entitled to those service-connected compensation benefits from the VA. So don't waive those benefits, don't lose those benefits, don't ever accept severance payment. If you have 20% or lower, you need to appeal your decision. This is the informal PEB. So if the informal PEB determines that you're fit, then again, they'll try to send you back to work. You can appeal the decision at the informal PEB. Either way, whether they say fit or unfit. The Air Force is a little different, but for the most part, you can appeal the decision. You'll go on and you'll get a formal Physical Evaluation Board, which is a board hearing. That's where we can submit new and material evidence. We can appear with you before the board. Some of them are virtual, some of them are in person. You really have the right to choose now. But you can go before a board and you can plead your case before a board, and they will make significant changes in many cases. I've litigated a case before the board where I got an individual from 0 to 50% disability retirement, and he'd been out of the military for 14 years. We got it for him. He was a National Guard member who did a 1-year deployment, and we were able to get him, we were able to establish 50% medical disability retirement for the rest of his life with a retro check backdated for 14 years. So as you can imagine, it was a life-changing outcome for him. So don't give up. Stay away from severance payments, and don't think that you can't fix getting kicked out of the military if you've got medical conditions that were aggravated or incurred while you're in the military. We started at the board with that case. He was kicked out, he got some type of negative discharge. We went to the board agreed and referred him for a medical evaluation board. Medical evaluation board determined he was unfit. IPEB determined he was fit. We appealed the decision, went to a hearing, and got him from fit to unfit and 50% medical disability retirement, permanent retirement rating for the rest of his life. So, but that's how generally that's how IDES and LDES works. The Integrated Disability Evaluation System / Legacy Disability Evaluation System. The biggest difference between the two is the VA is going to do an evaluation, and the military branch is going to base their percentage. They're usually going to cut it down a little lower, but they're going to base their percentage off of the VA evaluation. Integrated means they're doing both, so you're going to get your evaluation and you're going to go through the PEB process. Legacy or LDES means they're going to use the rating that you already have. So if you're National Guard or Reserves, sometimes you already have a rating, you're already collecting service-connected compensation. Instead of putting you through the VA's evaluation again, they'll just keep your numbers and use the current numbers that you have. It speeds the process up a bit, not a ton. But what we have to show in these types of cases, we go to the board, and again, as Eric was saying, the Discharge Review Board can't do this, so we have to go to the Board for Correction of Military or Naval Records, and we argue that you were unfit at the time of separation. Doesn't matter really what's going on now. I mean, it's relevant, but we want to be able to show that you were unfit at the time of separation. Because if you became unfit after you were separated, then they don't owe you anything. They shouldn't have retired you. We need to show that you were unfit at the time of separation, and then we always ask for alternative relief. So at the board, we would say grant the medical disability retirement at a level of 50% or something like that. And then in that same application, we would say in the alternative, if the board determines that a medical disability retirement is not appropriate, then we ask that you refer this individual for evaluation to the Integrated Disability Evaluation System or Legacy Disability Evaluation System. The board is reluctant to grant a medical disability retirement, so in most cases, they will just refer the individual, and then they go into the medical evaluation board process, and there's a decent chance that they'll get a medical disability retirement if they make it to that stage. These VA codes that they use, you can find them online, but they'll use the VA codes just like the VA uses when they service-connected condition and pay compensation, and they'll use the same guidelines built into that regulation for 10, 20, 30, 50%, whatever it is, but the military is usually a little stingier about it. They'll only give you conditions that are unfitting. They won't give you all conditions. So if you have, a knee problem and they think you can still do your job, they're not even going to consider that condition before the MEB and PEB. But if you can show that it limits your ability to perform the duties of your rank, grade, or rating, then they'll consider that condition and they'll assign a percentage to that condition. Over to you.
All right, so some of the other common filings, clemency, which is, just saying, hey, I know I got into a little bit of trouble in my military career. I've gone out, I've done all these great things post-service. I think it warrants a discharge upgrade. Typically, if you go back to that statute of limitations for the board, 3 years, if your argument is based upon clemency, they're always going to waive that because their board's typically looking for about 15 years of good service good post-service conduct. You're not going to be able to relitigate certain court-martial convictions. Your BCD, not going to be able to do that. There's one memo actually that came out. It is the Wilkie memo. You may have seen it referenced in a couple slides previously, but it kind of lists a bunch of considerations that the board should go through when deciding whether or not to grant relief based upon clemency. Again, if you've built out a very, very thorough petition and you have some good post-service conduct, there's a pretty good chance the board's going to go ahead and upgrade your discharge. You may, turn your OTH into a fully honorable discharge. You may only get a general discharge upgrade.
You got one back today, right?
Yeah, same thing, general. Yeah, I had a client who got a little bit of trouble, in service, post-service, excellent history. We applied to the board. Board agreed with us. They agreed to upgrade her to general. So it was a nice victory. And a lot of time, you get these a lot of times. And if you do ever go back to that reading room, you'll see that you're looking at about 15 years, and you'll get a good idea of what the board's looking for as far as post-service conduct goes. One of the other common filings we see is discrimination. So I think if you go back to 2017, there was a disparity report that was released that showed really widespread discrimination throughout the military justice system. Boards aren't always going to admit that a service member was discriminated against. But if you give them some type of alternate argument, they may, disregard the discrimination, but grant you relief on something else. So, for example, you may think you were discriminated against, during NJP, and the severity of your misconduct didn't really warrant separation. So you make that argument of discrimination, but you may say, hey, even if you don't believe that was true, I do have a little bit of good post-service conduct. Relief is warranted at that stage. Board's not going to admit they discriminated against you, but it likely increases your chances of success as far as that clemency argument goes. Another common filing we see deals with don't ask, don't tell and its predecessors. Again, there's another memo that came out providing guidance to the board and how they should really go about reviewing these applications and the factors they need to consider with relief. A lot of times they will go ahead and upgrade your discharge characterization based upon that if that is the only reason why you were kicked out. Even if you were kicked out with a little bit of, post or a little bit of misconduct in service, nothing too egregious, but ultimately you can say, notwithstanding that post-service misconduct or in-service misconduct, there was a sexuality or anything like that was taken into account when issuing that service characterization, you're likely to get relief. Request for reconsideration, that last bullet point down on that slide. So if you apply to the Board for Correctional and Military Records, you have a right to submit a request for reconsideration. You can do this at any time. There's no statute of limitations. The only requirement is that you submit new material evidence or argument that wasn't previously considered by the board. So for example, if you go back and say you had an OTH, you applied to the board upgraded you to a general, for example, you think you warranted a fully honorable. If you can find new and material evidence or arguments, you can submit a request to get that upgraded to a fully honorable. That goes the same thing if they were to just deny relief outright. If you can find new evidence and argument, put together a very nice package, submit it, the board has to consider it. They're not going to kick it back for statute of limitation reasons. Anything else you want to add?
No, well, the discrimination one that you brought up some good points there. I personally litigated a case a couple of years back. It was an Army board case. Two individuals, both males, both sergeants. One far more qualified than the other, but he was the minority. And those two individuals both failed the same drug test. Both went before the same board, and guess which one they retained? They retained the white guy. They kicked the minority out, which is typical. So I litigated that case. We did our written submission, and our written submission was denied, but as we talked about earlier, you have the right to appear before the Discharge Review Board. So we exercised that right, and I appeared with this individual in Crystal City, Virginia at the board, and we made two arguments at the board. One of them was that he was discriminated against because he was discriminated against. There's no doubt in my mind, it was very obvious. And then the other argument we made was, I think, a clemency argument or something that was not even really all that well supported. It wasn't a great argument. We didn't have a ton of great evidence. But, we made that conscious choice intentionally to try to give the board an opportunity to grant relief if they wanted to grant relief, because I was confident that they weren't going to admit discrimination. And then lo and behold, we got the decision letter, we won. Our guy was bumped all the way to honorable, actually got his job back because he lost the job that he had. There were other, collateral consequences of the upgrade, but he got his discharge upgraded, and the board, didn't even mention discrimination in the decision letter. They talked about his post-conduct service, which there wasn't really all that much to talk about, but that was the out they were looking for. They granted relief because they knew he was discriminated against, but they didn't want to create a record showing that the Army discriminated against him, so they granted relief, and they gave us our alternate reasoning. So keep that in mind when you apply to these boards. Give the board an out sometimes if you think that they're not going to want to grant relief. All right, we'll briefly talk about writing the application. Again, as Eric and I have mentioned, we're not going to be able to teach you how to do legal writing in an hour, but these are just some tips that help us to increase our chances of success at the boards. Some of you might be VSOs, some of you might be trying to do your own application, I don't know, but there was a recent article published. Feel free to Google it. It's not that difficult to find, but I say recent, it was a couple years ago now, that some of these boards take as little as 4 minutes to review an application. So think about that. You go through and you submit this veteran's application, or you're the veteran yourself, you put a bunch of work and effort into this application, submit it to the board, you wait 2 years for them to review your application, and they spend 4 minutes on your application. I mean, that's ridiculous, but that's what you're dealing with sometimes. And it's not all of them, but at this time, it was very common when this article was published. So you have to take some steps to make sure that you get your most out of that 4 minutes. Do your best to give them exactly what they might be looking for in that 4 minutes, and that will drive your chances of success, quite high compared to if you didn't do these things. So be clear and concise. If you are going to write a book, if you're going to be verbose, if you're going to add a bunch of fluff, a bunch of language that doesn't really make a statement, then you're wasting your time. They're not going to read all that stuff. So you want, our applications, our legal briefs generally are 7 to 15 pages. And then we've got sometimes 100 pages of supporting documentation, but it's all identified in the brief and it's all very clearly labeled, because my belief is that the members of the board look at the application, skim it quickly, see a heading, see a label, see something that they want. Oh, this is a Hagel memo case. Okay, is there a PTSD diagnosis? and then they can look right there in the enclosure section and see that it's enclosure C. They flip to enclosure C, a doctor says you got PTSD, okay, I'm done with my review. I say I vote for an upgrade. And I really think that that's how these applications go sometimes. I've sat on boards, I've sat on promotion boards and different boards in the military, and I can tell you that the review is not always as thorough as it should be, and there are articles written in the media about the lack of effort that has gone on with some of these boards in their review of these applications. So another tip is use we call a roadmap. In our discussion or our argument section, we create a roadmap which basically highlights all of your arguments all in one short paragraph, and then we use really clear headings throughout the discussion section. So if they're looking for a certain argument that they've keyed in on, it's really easy for them to find that argument because they look for that heading. And then in law school, you're taught IRAC and CREAC, and it's just a way to format your argument in each section. So you would start with your conclusion, you would talk about the rule that you think was violated. Remember, you got the impropriety or inequity or error or injustice. Somebody broke a rule, that's your argument usually. So you explain the rule, you give an explanation of the rule, you give an analysis of the facts compared to the rule, and then another conclusion. You restate your conclusion. So that's the best formula that we've had for success. It makes it very easy to follow for a reviewer. These usually aren't attorneys, so we don't make a complex legal argument. We do sometimes, I mean, depending on the type of case. But and then we talked about it earlier, we try to include prior board decisions for persuasive purposes. They're not going to be controlling. Anything you want to add?
No, I think that goes on everything we needed as far as writing goes.
All right. Talk about advisory opinions.
Yeah. All right. So advisory opinions, what are they? They are exactly what they sound like. So, say we'll use a MDR case, for example. You petition the Board for Correction of Military or Naval Records for medical disability or retirement. You put together your package, you have your evidence. The board will then take your petition, take all that evidence, and they will put it in front of a medical provider. The medical provider will review it. They'll make their opinion. At the end of the day, it's a recommendation. They send that back to the board. The board notifies you of the advisory opinion itself. It gives you a copy. It also gives you a timeline to respond, which is 30 days from receipt of the advisory opinion. To be honest, a lot of these advisory opinions are almost always garbage. They will recommend denying relief, or they, will say, hey, if you're going for a fully honorable, they may say, we just recommend a general. As far as responding goes, you always want to respond to the advisory opinion, because at the end of the day, it's just a recommendation. If that opinion is favorable, there's no requirement for the board to follow it. So by responding to it, you kind of get to wave it in the board's face and say, hey, look, even your own legal advisor or your own medical advisor agreed with us, and this is why you need to grant relief. If it's unfavorable for some reason, it gives you the opportunity to get the last word in. You can poke holes in any of the reasoning. You can also submit new evidence to the advisory opinion itself. I think I actually just did this today. It was about 200 pages worth of medical records. So those are the advisory opinions. Will you always get one? Typically, yes. Sometimes, and just recently, the board has been sneaking these into their decisions. What I mean by that is they've reached out to their medical, they've reached out to legal, they've got an opinion, they haven't notified you of that opinion, but they've relied upon it in reaching their decision. It's a due process issue on that. That's a whole different argument, but those are the advisory opinions.
Yeah, that's something we're going through right now. So in the past, what the board has done on multiple occasions, and it upsets clients quite a bit, is they send them a decision letter and they say, we sent you an advisory opinion and you failed to respond to it. And we've never, for a lot of these cases, we don't receive an advisory opinion. They're lying, they're being dishonest. Or whoever's writing the application just assumes that they sent us the advisory opinion. So then the individual gets mad at us and thinks that we just ignored an advisory opinion. We would never ignore an advisory opinion. But it happens from time to time where we get accused of it. And then now, as Eric was saying, now sometimes they don't even bother to send them or claim that they sent them. They
just smuggle them in there.
Yeah, they explain that they received an advisory opinion, and statutorily, we're supposed to receive the advisory opinion and get 30 days to respond to that advisory opinion. But some of the boards have been denying us that opportunity over the past maybe 6 months to a year. So it's new. This has never happened to us before. So we're kind of going through a little bit of a struggle right now with the boards. We might take some action and maybe initiate a congressional or request a congressional into that. But everybody should get an advisory opinion, but you don't always get one. Sometimes they just make the decision. And as Eric said, they're garbage sometimes. I mean, they're the typical, I didn't do anything wrong, our branch is perfect, we don't ever do anything wrong, we deny relief. Of all the cases I've worked, I think I got one where, ironically, the advisory opinion was recommending that the board grant the relief, and the board denied the relief anyway. So it was pretty crazy to get a case like that. So then we followed up and we did a request for reconsiderations. And how can you deny the relief? The branch told you to grant the relief, and you then went on to deny the relief, and they realized their error because the board's sloppy and they probably didn't even read the advisory opinion, and they ended up fixing it and granting relief in that case. But it happens, you know, the advisory opinion is just, it's a part of the process, but it almost never works out in the veteran's favor. All right, so we're gonna field some questions here. Eric's gonna look at some on his phone, but in the meantime, I compiled a bunch of questions. So Taylor and Pat sent me over a spreadsheet of all the questions that you all submitted, and I tried to compile some of them. I tried to answer some of them throughout the presentation. I know Eric did as well. We actually revised the presentation slightly to include answers to some of your questions. So some that we didn't answer, we'll go through here quickly. We've got a little bit of time. So success rate, we talked about that. You can find the success rate right there in the reading room, but know that success rate is a reflection of all of the applications that go in. And if you do a really good job with your application, if you support it properly, if you draft the brief or your petition the way that you should, all those tips that we talked about, and you know, there's more, obviously some more intricacies, but if you submit a really good application, your success rate is not going to be the same as the success rate that's published on the websites. You will exponentially increase your success rate, because that success rate includes people who just submitted just a DD-149 or just a DD-293 and didn't actually build out their application or supporting evidence. There was a question about whether your employer might know if you apply to the board and get denied. They shouldn't. You know, if it's a case where the employer will ask, and this happens sometimes during the background investigation, especially federal agencies, have you ever received a dishonorable discharge or anything other than an honorable discharge from the military? And sometimes they'll ask you for your DD-214. Under those circumstances, they're still not going to know if you applied to the board. They have no idea. So nobody's going to get this information but you, and if you have one, your legal representative or your VSO that's helping you, something like that, somebody that you list on the application. Nobody else is going to get this information unless you want them to have it. There was a question about burial benefits with an other than honorable discharge. There is actually a page for this. VA does a pretty good job with their websites, but you can actually go on and just Google burial benefits, and don't look for when you Google something like this, you're going to get a whole bunch of attorney ads that will pop up. People who want to charge you to answer questions about burial benefits or something. You know, that's something that you need to apply with. Just know that an attorney can't help you with a VA claim, which is technically what this would be, if you didn't apply and get denied already. So we do appeals, we assist with appeals for individuals for VA cases, but we can't do your initial application. Attorneys don't do that. You know, you go to a VSO or you can do it on your own, and if you get denied, we can jump in and you can retain an attorney at that time to appeal the decision. But you won't get burial benefits in most cases with an other than honorable discharge. You can check out the circumstances that might allow you to, but you go to the burial benefits page on va.gov. So again, skip past the ads and look for the va.gov website. Go there. You can read about burial benefits, and there's an eligibility page, a little button off to the left there. You can click on that option, and it'll take you to the eligibility page, and it will explain who is eligible. You know, family members can be eligible, things like that, but you got to start with an honorable discharge. If the VA doesn't consider you to be a veteran, they're not going to give you burial benefits. And to be a veteran in the VA, they want to see that you didn't get a dishonorable discharge. All right, medically discharged, but doctor now says you are fit. This happens. This happens quite often. I think in this question, the individual was saying, for example, a birth defect. If something like that happens, and again, I think the example was maybe 14 or 17 years in the military, something like that. This happens. There is no smoking gun. There's no guarantee that you're going to be able to get back into the military, but you would have to get probably a recruiter involvement. You'd have to apply to the board to change the paperwork. There's a couple of different steps and a couple of different actors that would have to be involved here, but you'd have to show that you're fit. You'd have to clear, depending on how long you've been out, if you're fully out, you'd probably have to clear MEPS again. Is that what you're going to say?
Yeah.
Yeah, you'd probably have to clear MEPS again and be cleared to go back into the military. And for those of you who spent 17 years or 14 years in the military, you're probably going to have a hard time clearing MEPS. I know by that point I would have had a hard time clearing MEPS. All right, so the next one, discharge for drugs, but didn't consider drinking contaminated water first. This was an individual, the question asked, he or she was referring to Camp Lejeune and all the stuff that's going on with Camp Lejeune right now. So know this, these are two completely different organizations. If you're applying to the Board for Correction of Military Records, we went through the types of applications and what would help you build out a strong case. And then the contaminated water, that's the Department of Veterans Affairs. That's a different organization. They don't have anything to do with the Boards for Correction of Military Records. Different organization, different relief. That said, you can go to the VA and request a classification of service upgrade for VA purposes only. It's unique. I've done it, but a lot of people haven't, and a lot of people don't get success with that. But I had an individual who was shot and wounded in the Korean War, was later separated, was discharged. I filed, he'd been fighting it ever since, I don't know, 50 years. It was a really long time when he came to the firm. And he tried all kinds of applications, all kinds of attorneys had tried everything, but none of them were able to get relief. I have first filed the Board of Corrections applications for a discharge upgrade, and then I filed with the VA to consider his service something other than dishonorable for VA purposes only, is the way that we word them. The VA immediately granted my request. He called me from the lobby. He was very happy because he had fought this for so long. Got hundreds of thousands of dollars in back pay from the VA. Was immediately service connected at 100% and got health care benefits, everything moving forward. And we ended up getting him his discharge upgrade through the military branch as well, but that takes 2 years. So you can do both. You can apply to both, but the two aren't necessarily connected unless something that caused some type of illness related to drinking the contaminated water at Camp Lejeune was an underlying factor or the cause for the misconduct that resulted in you being kicked out or separated. So this goes back to that PTSD Hagel memo argument we were talking about earlier. You've got good soldier, you've got traumatic experience, and then you've got misconduct. And you can say that that's the order it went, and the misconduct was the result of or closely related to the trauma that occurred. If something happens where the contaminated water becomes that trauma or something related to that, then you might have an argument to make that contributed to the negative discharge. Hope that makes sense. Difficult nexus to draw between drinking contaminated water and drugs, obviously. But some people self-medicate, some people do things that they didn't do before, and it's certainly an argument that you could make, and there's a potential that you could win that at the board. And then closely related, we got a bunch of these questions. Discharge for drugs, can you still get an upgrade? Absolutely. We do it all the time. So you can show self-medication, you can show that drugs was the misconduct that followed maybe a traumatic experience in Iraq or Afghanistan. In the past we had a case where an individual, I believe his sister was sexually assaulted. That affected him mentally, and he, led to him drinking, and then he got into some type of misconduct. And we can seek an upgrade for something like that because we can show that there's underlying causes for the misconduct. So you can absolutely get a discharge related to drugs upgraded. We do it all the time. You just have to have good post-service conduct, or you have to have a good fact pattern for when the individual is in the military, or both. Timeline for an upgrade, I talked about that, but you're looking at, I'll say 1 year to 3 years, but a year is extremely rare. Some of the discharge review boards do a good job of pushing the cases through a little more quicker than the Boards for Correction of Military Records, but generally you're looking at, up to 3 years to get relief at the boards. It's a really long, drawn out process.
And they do expedite them depending on, whether or not you're alleging some type of underlying mental health condition. I had one come back actually that in about 7 months, just recently, so.
They'll say they don't. They'll say they do them first come, first serve, but if you get a congressional under certain circumstances, they can pull them to the top of the stack. And there's other times when they might as well. Still got a few more you want to plug through these.
I got a couple here that I actually probably do. So we got one, and it really goes to, what is considered an error or injustice. An error, you're looking at some type of regulatory error, meaning the military didn't follow their own regulations when they were discharging. I think frequently we see this with OTHs and ADSET boards. In order to give somebody OTH, you have to put them before an ADSET board. If you don't, the least favorable characterization they're going to receive is a general. So a lot of times you will see commands either completely disregard this intentionally or just out of ignorance, and that's really your error standard. Your injustice standard goes more towards, hey, I was in for 18 years of service. I had a spotless record. My wife divorced me. I got a DWI. This is the first time I've ever been in trouble. I was at 19 and a half years on the day I got separated. That's your injustice. So I hope that kind of clarified that question for you.
And sometimes we can get constructive credit for cases like a reservist, for example, who's done over 19 years and maybe had enough points to qualify for 20 but wasn't in for the full 20. Sometimes we can get constructive credit and get them their retirement instead of just a separation. Because a lot of reservists don't know any better and they'll retire right at the 20-year mark, and then they'll find out 20 years later when they turn 60 that they were, a month shy or 10 points shy of a retirement or something. It's pretty crazy that they do that, but sometimes the board will grant relief on those cases.
We got another one that goes to really the statute of limitations. Like we explained earlier, you're at 3 years for the BCMR. They routinely waive that. You'll see, I just won one for a Vietnam vet that had just recently applied, through 30 years maybe after service, 40. So they routinely waive them. So, you're discharged from 82, from the, even the 90s, even the 50s, it's possible to get those upgraded. Boards routinely waive that statute of limitations as long as you can convince them to do so.
All right, I'll jump back into some of these here. So last one was timeline for upgrades. How do I appeal? How do I appeal a previous denial? So we talked about that a little bit earlier. That's going to be your request for reconsideration. Eric talked about it. You just have to present new and material evidence or evidence that has not yet been submitted to the board or arguments that have not yet been considered by the board. So you can do this if you filed an application and the board considered your application. And this is a recent change. They changed it about 2 years ago, I think, 2-3 years ago. You can now file a request for reconsideration of that application and that decision for the rest of your life, if you can provide new and material evidence. So there is no longer, at least right now, there is no limitation to when you can appeal a Board for Correction Military Records decision, as long as you can provide new and material evidence. Now, the next step after the boards is federal courts, and federal courts generally have a 6-year statute of limitations. So it's difficult to get past that statute of limitations later, beyond the 6 years. So say you file an application, they deny your application, and now you want to go to federal court. Well, it's difficult because the only argument you really have if you're beyond the 6 years from error, injustice, or discharge is that you would argue that the board's action in denying your relief created a new 6-year statute of limitations and you want to file an appeal based on that. It's tough, and you may or may not be able to get it through depending on what issue you're dealing with and what your argument is. But as far as the actual boards themselves, you can apply for the rest of your life as long as you can provide new and material evidence. Where are we at? Okay, so an upgrade of, I think the question was asked if an individual can get an honorable if they got kicked out with an entry-level separation a few weeks in following a military sexual trauma. Sounds like a pretty crazy question, but it happens all the time. We've all been there. Basic training, something happens that you think is funny, it's hazing, whatever, the group thinks is funny. It's sexual assault in some cases. It's military sexual trauma. And that traumatizes some people. So in this case, if an individual were to have joined a military branch and somebody did something to them that was considered to be a military sexual trauma, then there's a decent chance that they could get some type of relief. You might be able to get VA benefits if whoever's asked this question. You might consider applying for VA benefits because it is a condition that was aggravated or incurred while on active duty, and if you don't already get service-connected compensation, you might be eligible for service-connected compensation, and then you can go back to the board and you can request that the board grant an honorable discharge instead of an uncharacterized discharge. An uncharacterized discharge happens with entry-level separations, and in most cases that means the individual didn't get to 180 days in the military. If you don't get to 180 days in the military, and then in the Navy, it's slightly different. If you don't complete your initial skills pipeline training, then you can get an entry-level separation. It's not supposed to be negative. It's not supposed to look negative, but try getting a good job at a federal agency with an uncharacterized discharge. And you'll see quickly that they view that negatively because they just don't understand what it is. So you can apply to the board, and there is a chance that you'll get that upgraded to an honorable discharge if you've got evidence that you're the victim of a military sexual trauma or any of the other stuff we discussed. How do I upgrade my reentry code? So you can upgrade. That's what the RE code is, and it you'll see sometimes on your DD 214 RE1. That means you're good. You can go back into the military at any time as long as you clear the MEPS or the fitness portion. RE2, RE3, some of those are waiverable, so you just have to get a commander to allow you to come back in. And then RE4, you're not going to be able to go back in unless you get that corrected. So you would go to the boards. You could go to the Board for Correction of Military Records for the RE code. You could go to the Discharge Review Board. Some administrative relief, there's very few circumstances where you can request administrative relief other than the discharge upgrade at the Discharge Review Board. But if you're requesting a discharge upgrade anyway, then request that they also change your RE code. Because if you don't ask for that relief, they might not grant it. You might have an RE4, you go to the Discharge Review Board, and all you request is an upgrade of your discharge. They could give you an honorable and leave your RE code as an RE4, and you can't go back into the military. So make sure that you request all of these specific types of relief because they're not going to give you anything you don't ask for. That's not how it works. So you can upgrade your RE code at the boards. Can my discharge from 1982 be upgraded? We do that all the time. Like I said, the Korean War was, I think, as far back as I've gone to get a discharge upgrade. Vietnam veterans, we do that often, and that's well before 1982. So you can certainly upgrade your discharge from back then if you can meet any of the elements that we discussed here today already. Upgrading an AWOL discharge from 20 years ago. Same thing, we can upgrade it. If you've had 20 years, then you've had a really good period of time. So this is one of our interest of justice arguments that we make to get around that 3-year statute of limitations. Because you're at 20 years, so you're more than 15 years, so you can't go to the Discharge Review Board. Now you have to go to the Board for Correction of Military or Naval Records. You're at 20 years, so you're obviously beyond the 3-year statute of limitations. But we're going to argue that we would like them to consider the application in the interest of justice. And one of the arguments that we're going to make, if it's been 20 years, is that we understand that you should have applied within 3 years. Maybe you didn't know that, but 3 years wouldn't have been a very good period of service to determine what your post-conduct service is going to look like. 20 years, you've had 20 years now. You've established a career, you've got a college degree, you've gotten married, you have kids, you've done all these different things, you've volunteered in the community. I've had an individual become a doctor, and go and do these missions in other third world countries. You do all these things in 20 years, and that's a big opportunity, a big window for them to look at for your post service conduct. So yes, you can get an upgrade after 20 years. Clemency is usually your best argument under those circumstances. Where do you get the forms needed to apply? So we've talked through this a bit. You can get them on the website, but keep in mind those forms are almost never enough. There isn't a form for a legal brief or a petition. You're going to want to write that. You're going to want to take the time to explain what happened because they don't have all of the facts and you can't fit all the facts in a box this big on a form. If you submit just the form, there's a really good chance you're not going to win your case. So you can get the forms on the internet. You can get them right on the websites, on the website we had on here earlier at the reading room and other sites. And you can submit that form, but make sure that you submit it with supporting documentation and a petition or a brief to support your claims. All right, already submitted. This is a good one. So already submitted, but not good enough, and how can you fix it? Well, if you already have an application, let's say that you're one of the people right now that I'm talking about, and you go, oh, I submitted a DD 149 a year ago, and that's all I sent in. Now you know there's not a very good chance you're going to win your case because you didn't support it very well. We can draft and submit, or you can draft it. See, I got at least one. You can draft and submit what we call a supplemental petition. So what you would do is you would draft this legal brief, you would develop all of this additional evidence to support your initial application, and you would send it to the board and you would say, I have a pending case at the board. Here's my name, here's when I submitted my application. I've got a pending case before your board. I would like to supplement my record, supplement my file with this additional information and evidence. And usually it'll keep your place in line because your application's already there and pending. They can just add this because the board hasn't reviewed your application yet anyway. So they can add this additional information and evidence to that. And by the time it makes its way to the board in another year, the board's going to review the whole packet. So you can do that. You can even put an application on administrative hold. So you can ask the board not to adjudicate your application until you provide additional evidence and information. That might slow the adjudication down a little bit, but it's better than a denial. You can put it on an administrative hold and supplement the record. But in most cases, you don't have to put it on hold to supplement the record. You can just put the supplemental submission together and get it submitted as quickly as possible.
To kind of jump in and expand upon that. So these boards are investigative bodies. They're not going to go out and figure out what arguments you should have made. They're not going to say, hey, for the most part, you really should have, we can grant relief on this aspect, or let's check to see if this happened. You really are stuck with only having the board consider whatever arguments you made. They'll go out, they may get your military records, they may get your service treatment records if you're going for an MDR. But for the most part, if you just submit that form and nothing else, or even if you submit, one or two pieces of documentary evidence, it's typically not going to be enough to persuade the board to grant whatever relief you're looking for. So just keep that in mind.
All right, I see we're a couple minutes over, but I want to finish this up and get through a couple more questions. I know you all appreciate it if we answer these questions. So is it automatic, right? How many of us have heard when you get out you get 6 months? There's one already. How many of us have heard that? Well, it's okay. In 6 months it'll be an automatic upgrade. There's no such thing. That's not a thing. People in the military should know that's not a thing, but you don't have a reason to know that because you're in the military. You don't have to request a discharge upgrade. Nothing is automatic. There is no waiting period, so you don't have to wait to a certain period to apply, especially if you think your discharge was an error or injustice or an inequity. If you think that they did something where you can show impropriety, they didn't follow the rules. Eric was talking earlier about an administrative separation where they didn't give you the right to an administrative separation board. That's an easy one. And if they can't prove that they gave you the option to go to a board, then you win. So you want to file right away if you think there's an error or injustice or something like that. The only time you wait is if you're trying to build up clemency, you're going to argue clemency, you're trying to build up that post-service conduct. Then you might want to wait a little bit and establish a good record to improve your chances of success at the board. When is a good time to go to the board? Anytime. I just kind of talked through that. So if you think it's an error or injustice, as soon as possible. If you think that you're going to argue clemency, then after you have volunteered a little bit, coach youth sports, go volunteer at your church, get a decent job, hold it for a little bit, go to college. There's different things that you can show good post-service conduct, especially volunteering, things like that. And once you can establish a few of those things and show a pattern, then apply to the board for clemency. And then CRSC and CRDP explanation. So I plug this one in at the end because there was kind of a bunch of questions about the two of them. So I'll just briefly explain the two of them and know that you can find this at va.gov as well. There's a pretty good explanation of it. So CRDP, just to get that one out of the way, CRDP is concurrent retired disability pay. That's for an individual who is eligible to collect both retirement and service-connected compensation from the VA. Two completely separate pots of money. People get this confused a lot. They'll ask about their retirement, but they're talking about the VA. They're not related. or they'll ask about the VA, but the military pays your disability retirement. So they're not the same thing. They're different pots of money, different organizations. One is the military branch, the other one is the Department of Veterans Affairs. So CRDP means that for some reason you may be entitled to both at the same time. So a reservist who turns 60 is eligible to collect their reserve pension, and they're also maybe service connected and they're collecting VA compensation. You can collect both at age 60. An individual who gets out of the military with 20 years of active duty, they have established entitlement to an active duty retirement, and they can collect their service connected compensation at the same time. So that is concurrent retired disability pay. Where we have some issues is where individuals get medically separated and they also want to collect their VA compensation. So that's combat related special compensation. We have to be able to show that the individual was medically retired, they're collecting their they're collecting their retirement benefits, their pension, which is treated like an active duty pension, but you haven't actually earned the 20-year retirement. You're not otherwise eligible for retirement is the language that the VA uses, and you'll see that at va.gov. But if you're medically retired and not otherwise eligible for a retirement, then you would get your medical retirement offset by your VA compensation. So you'll take the VA compensation because it's tax-free and your pension's not. You'll take the VA compensation to whatever number they'll give you. If you're 100%, then it's $3,500 or whatever it is right now. So you'll get that money in tax-free compensation, and then they will subtract that from whatever your medical disability retirement money is, unless you can establish combat-related special compensation. So you were injured as a result of conflict or war, you were injured at war, you were injured by an instrumentality of war, you were injured under certain circumstances training for war, like jumping, doing modern Army combatives, or hand-to-hand, some type of training, and you can establish combat-related special compensation, they'll waive the offset and you'll be able to collect both. So I hope that is a decent explanation of how CRDP and CRSC work. But again, you guys can reach out to us after this if you have additional questions. Do you have another one you want to do, or are we good to go?
No, I think we're good to go.
Okay, well, thank you all for joining us. We appreciate it. We hope this has been insightful for you, and we look forward to seeing your faces again. I know we're working a lot of your cases right now, or some of your cases right now, and we hope for success in your cases as well. I'm sure you do. But feel free to reach out if you have any questions about your case. If you don't have a case with us, feel free to reach out. We'd be happy to answer any questions that you have. And if it's appropriate and you want to move on to retain the firm to appeal, we can do that as well. But it's entirely what you all want to do. I see the clapping and stuff up there, so we got some people who enjoyed the
Perfect.
Good. If there's anything we can do for you in the future, don't hesitate to reach out.